following is my documentation that there exists a conflict to the public's interest, whereby this entire court must recuse itself, to having robed attorneys complicit in racketeering against the public's insurance companies, deciding what level of extortion should be applied to keep the insurance draws from which the judiciary is feeding its kind upon the public from hearing such issues as my driving without insurance. On the basis that you and all judges are subject to a court administration and membership which openly colludes and conspires to violate the trial-related limitations on your authority provided by the Constitution, the Bill of Rights, and numerous laws of consequences, conditions of your authority, you have forfeit your authority. I deny this court authority over me, and nothing I say at any time should mislead you to believe I have granted you any authority over me at all until such time as the changes I have demanded in here to put a stop to your racketeering activities against the public are implemented in total. I have presented oral and more recently written explanations of these conflicts of interest in other matters in my next investigation, which will be prepared shortly hereafter, and have documented that the court will not recuse themselves, and so I am recusing you. Being as your authority is forfeit, I'm the authority in this, my courthouse. You are a bunch of criminals and have no authority. The following is a documentation of an investigation I conducted which documents that the trial, appellate, and federal courts are engaged in a conspiracy and collusion to protect attorneys and chiropractors and other co-venturing attorney assistants conducting frauds in our courts against the citizenry and its insurance companies by numerous means forbidden by the Constitution and Bill of Rights, including concealment of presented records, forfeiture of cross-examination, jury tampering, etc., which shall be covered here. This is also a documentation that demonstrates that the court will not enforce forfeiture of office. In other words, due process through the trial, appellate, and federal courts is an absolute farce. And that it is necessary that a judge's authority be automatically forfeit by the action or the engagement in collusions to conduct such violation of Constitution and right. And as far as I'm concerned, judges, so-called judges, not informing the public of this collusion of the court, which is so brazenly demonstrated here that they could not all not be aware of it, constitutes intent to aid and abet such frauds upon the public. I will shortly provide a documentation of another case, Moore v. Brayler, which documents further that this protection is also provided by the Small Claims Court. That this protection is known to most, if not all, attorneys, and thereby prevents attorneys, or shall we say extorts attorneys, to deny representation to victims who hold and or might have to present on a citizen's behalf attorney or co-venturing chiropractor incriminating evidence is just common sense. In other words, that this protection that you are providing denies the public protection from the crimes the court is promoting is just obvious. The trial, appellate, and federal courts are promoting and thereby organizing attorney fraud against the public and its insurance companies, and whereby I say organized criminal racketeering enterprise. The court's marshals, clerks, and stenographers are complicit in this racketeering by failing to bring such treason and tyranny to the public's attention. It is these acts of malice which prevent attorneys from The primary duty of each branch of government, that is, the other two branches, of each branch of government, is to provide, on the public's behalf, oversight over the other two branches and consequences. The judiciary, because of its racketeering activity, poses no threat of even oversight, and the other two branches, composed almost totally of attorneys, likewise protected, are freely diverting our taxes to those who finance their campaigns. See, the root of all evil, as you shall see, is campaign financing. The primary function of both parties in government, due to this lack of judicial oversight and consequences, has become that they are trading campaign financing and kickbacks in exchange for transferring the public's taxes and wealth to their kind and their contributors, attorneys being a major contributor. Campaign financing, contrary to the court finding that it is protected under access to the government and freedom of speech, is in fact the right of the very few to silence, to prevent government access to the public, and to buy deaf ears of our legislators to any of the public's needs. That is to say, the non-contributors' needs, or the small contributors' needs. Absolute power corrupts absolutely, and I believe you are absolutely corrupt. Judicial. What this is a documentary, which I hope will be by law required viewing for all prospective juries, so that they will become aware of the organized criminal racketeering activities and the practices and procedures employed by you to tamper them and to racketeer against their kind, their other citizens. Judicial racketeering depends upon certain procedures as demonstrated against me, which we must remove from their arsenal of practices and procedure as herein exposed, in order to recover our courts and our country. Any refusal or obstruction of process, such as rejecting or refusing my appeal briefs, must be accompanied by a written explanation, not "we don't have to tell you." Any action by any judge to conceal evidence, to obstruct presentation of evidence, shall be accompanied by the law. And I don't mean part of the law, as in this case. I mean the whole law. Readiness and ex parte hearings and conferences in chambers or at meeting places must be videotaped. This is not the 1800s. This bullshit behind which the judges can conduct this kind of criminal activity against the public has got to come to an immediate end, and videotaping has to be installed. Furthermore, the videotaping shall have 4 copies, which can be removed by any party and replaced with another tape, and the court can continue on at any time. 1 for the jury, 1 for the court, 1 for each of the 2 parties. The legislative and executive branches are likewise malfeasant and engaging in tyranny and treason in not providing their primary duty, which is oversight and consequences for such activities, because they are dependent upon campaign financing. The court's motivation is to aid and abet fraud. The court's motivation to aid and abet frauds against the public is an opportunity to be seen by attorneys who will elect them as delivering the law school promised protection to thereby elicit campaign financing and votes from attorneys at their next nepotism party election. The court's motivation is to maintain a level of injustice sufficient to... Could you check on that? I think it's our dog out in the alley. The court's motivation is to maintain a level of injustice sufficient to